Stop right there. Did you know that a recent 7-1 Supreme Court decision has fundamentally changed what happens the moment a police officer approaches your car or your front door? For decades, we've been told that being helpful is the best way to stay safe. But today, the legal landscape for seniors has shifted. One wrong sentence, even one intended to be polite, could now be used to bypass your Fourth Amendment protections under the new totality of circumstances standard. If you're a pensioner or a retiree, you have the most to lose from a legal misunderstanding. In this video, I'm breaking down exactly what the High Court just decided and giving you the precise four-word phrase you should use to protect yourself, along with the three common polite traps that could accidentally waive your rights. I promise that by the end of this short update, you will feel 100% confident in handling any interaction with law enforcement while keeping your dignity and your rights intact. If you value staying informed and protected in your retirement, please hit that like button right now. It helps us get this vital legal protection out to more seniors across the country. Now that we've set the stage with that incredible 7-1 ruling from the Supreme Court, we really need to sit down and talk about what this means when the rubber meets the road. You see, for most of us who grew up in a different era, we were taught that if a police officer pulls you over or knocks on your door, the best thing you can do is be as helpful as possible. We were raised with a sense of civic duty and the belief that if you haven't done anything wrong, you have absolutely nothing to fear. But the legal world has changed significantly, and this latest decision from the highest court in the land is a massive wake-up call for every senior in this country. It isn't about being anti-police or being difficult. It's about understanding that the rules of engagement have been rewritten in a way that often disadvantages those who speak too much. When the court hands down a decision with such a lopsided majority, they are sending a clear signal about how the Fourth and Fifth Amendments are going to be applied in the modern day. This means that your traditional way of interacting with authority might actually be the very thing that puts your retirement, your assets, and your freedom at risk. Let's dive deep into why this specific 7-1 decision is such a game changer for someone in their 60s, 70s, or 80s. Often, as we get older, we might feel a bit more vulnerable during a high-stress interaction, like a traffic stop or a surprise visit from an investigator. Your heart rate goes up, your mind starts racing, and you naturally want to de-escalate the situation by talking. We think that if we can just explain our way out of a misunderstanding, everything will be fine. However, the Supreme Court has now made it even clearer that totality of the circumstances is the standard that law enforcement will use. This means every single word you say, every nervous twitch, and every attempt to be nice is being added to a mental ledger that the officer is keeping. If you say, "I'm sorry, officer, I'm just a little rushed because I'm late for my grandson's graduation," you might think you're being relatable. In reality, you have just admitted to speeding and admitted to being distracted. Under this new ruling, that admission is a golden ticket for the state. This is why we have to shift our mindset from being helpful to being legally silent. Now, you might be wondering what exactly that 7-1 split was all about. It really centered on the idea of how much reasonable suspicion an officer needs to turn a simple conversation into a full-blown investigation. The court essentially ruled that officers have a broad range of discretion when interpreting your behavior. For a senior, this is particularly tricky. Sometimes we move a little slower, or maybe we fumbled with our registration because our hands aren't as nimble as they used to be. Under this ruling, an officer could interpret that slow movement or that fumbling not as a sign of age, but as a sign of nervousness or hiding something. It sounds unfair. And frankly, it feels a bit cold, but it is the legal reality we are living in. This is why the first thing you must do is stop offering information that wasn't asked for. You need to realize that the officer is not there to be your friend or to hear your life story, even if they seem very polite. They are there to gather evidence. And after this 7-1 decision, the threshold for what counts as evidence has become much easier for them to meet and much harder for you to challenge later in court. So let's talk about the specific words you should be using. I mentioned earlier that there is a four-word phrase that can save you a world of trouble. That phrase is simply, I am remaining silent. It sounds a bit formal, and it might even feel a little bit rude to someone of our generation who prides themselves on being well-mannered. But legally, if you don't explicitly state that you are invoking your right to remain silent, the courts can actually use your silence against you in some situations. Isn't that a strange twist? You have to speak up to stay silent? You need to say it clearly and calmly. You don't need to shout it or be aggressive. You just need to make it a matter of record. Once you say those words, you have created a legal shield around yourself. The 7-1 decision reinforces the idea that the burden is on the citizen to know and claim their rights. If you don't claim them, the state will act as if you don't have them.
This is especially important for pensioners because a legal battle can be incredibly expensive, and your retirement fund shouldn't be spent on lawyers just because you were trying to be a good citizen by chatting with an officer on the side of the road. On the flip side, we have to discuss the things you should absolutely avoid saying at all costs. The biggest mistake people make is trying to fill the silence. Police officers are trained to use silence as a tool. They will stand there, wait, and look at you, and our natural human instinct is to say something to break the tension. You might say something like, "I usually don't drive this fast," or "I only had one glass of wine with dinner." To you, that's an explanation. To the legal system, that is a signed confession. Even if you think you are helping yourself, you are often providing the missing piece of the puzzle that the officer needs to move forward with an arrest or a search. Another thing to avoid is asking, "Am I in trouble?" or "Why did you pull me over?" By asking these questions, you are giving the officer an opening to start a dialogue that they control. Instead, the only question you should really be asking is, "Officer, am I free to go?" If the answer is yes, you leave immediately and politely. If the answer is no, you go back to your forward phrase, "I am remaining silent." You want to take a moment to speak to the emotional side of this, because I know it's hard. I know that many of you watching have brothers, sons, or granddaughters who serve in law enforcement. You respect the badge, and you want to show that respect. Please understand that exercising your constitutional rights is the highest form of respect you can show to the country. The Supreme Court doesn't issue these 7-1 decisions just for fun, they do it to define the boundaries of our liberty.
By staying silent and being prepared, you are actually making the process cleaner for everyone involved. You are ensuring that the law is followed to the letter. Think of it like a business transaction. You wouldn't sign a contract for a new car without reading the fine print, and you shouldn't enter into a legal conversation with the state without protecting your interests. Your peace of mind in retirement depends on your ability to stay out of the legal system's gears, and this 7-1 decision has made those gears much sharper than they used to be. Let's look at a real-world scenario to make this hit home. Imagine you're driving home from a late-night community event. Maybe your taillight is out, and you don't even know it. You get pulled over. The officer is young, maybe the age of your grandson, and he's being very respectful. He asks where you're coming from. You tell him you were at the community center. He asks if you had anything to drink. You say, "Oh, just a little bit of punch at the social." Now, in your mind, that's an honest answer about a harmless event. But in the eyes of the law, after this recent ruling, that admission gives the officer probable cause to suspect you're impaired. He can then ask you to step out of the car for a field sobriety test. At our age, doing a one-leg stand or walking a straight line on a sloped shoulder of a highway at night is a recipe for failure, regardless of whether we've had a drop of alcohol. If you fail that physical test because of a hip replacement or just poor balance, you are now being handcuffed. All of this could have been avoided if, from the very beginning, you had politely said, "Officer, I'm not discussing my day, and I am remaining silent." This 7-1 decision really underlines the fact that the Supreme Court is prioritizing officer safety and investigatory efficiency over the casual convenience of the citizen. While we can debate whether that's right or wrong, we cannot debate that it is the law. As seniors, we have to be the most informed segment of the population because we have the most at stake. We have homes we've paid off, we have reputations in the community, and we have families who rely on us. A single misunderstood interaction can tarnish all of that in an afternoon. This is why I am so passionate about bringing you these updates. The world is changing fast, and the legal protections we thought we had in the 70s and 80s are being interpreted differently in 2026. You need to be your own best advocate. You need to be the person who knows the law better than the person standing at your car window. As we wrap up this deep dive into the body of this decision, I want you to remember that your silence is not an admission of guilt. It is a tool. It is a constitutional right that was bought and paid for by generations of Americans. The Supreme Court's 7-1 vote shows that even among judges with very different philosophies, there is a strong consensus on how these interactions should go. They expect you to know your rights. They expect the police to do their jobs. And when those two things clash, the person with the most information usually wins. Don't let yourself be the one who loses because you were too polite to stay silent. You've worked too hard for too many years to let a simple conversation turn into a legal nightmare. Keep that four-word phrase in your pocket. Keep your cool, and always remember that you have the right to wait for a lawyer before saying a single word. It's your life, it's your retirement, and it's your right to protect it. Thank you so much for sticking with me through this long and important explanation. I know we covered a lot of ground, and I know it can feel a little overwhelming to think about the law in this way. But knowledge is power, and by watching this today, you've put yourself ahead of 90% of the population. You are now equipped with the truth about what the Supreme Court expects from you. We're going to keep monitoring these rulings and making sure you have the translation of what they mean for your daily life as a senior. This is about more than just a court case. It's about your freedom to enjoy your golden years without fear. If you found this explanation helpful and you want to see more content that breaks down these complex legal changes into plain English, please make sure you've liked the video and shared it with a friend who needs to hear this. Let's look out for one another and make sure our community stays safe, informed, and legally sound. You know, it's worth taking a moment to look back at how we got here, because to understand where we are in 2026, we have to understand the history of our rights. Many of us remember a time when the neighborhood officer was someone you knew by name, someone who might have played baseball with your kids or attended the same church. In that environment, talking it out made sense. But as the legal landscape shifted through the late 20th century and into this current decade, the Supreme Court began to view these interactions through a much more clinical, legalistic lens. The 7-1 decision we're discussing today is the culmination of years of cases that have slowly chipped away at the idea of casual conversation with law enforcement. Today, the court views every interaction as a potential seizure or search. When we understand that the law has moved from a community-first model to an evidence-first model, it becomes much easier to justify staying silent. It's not that you're being a grumpy retiree, it's that you're being a modern, legally literate citizen who understands that the rules of the game have changed.
One of the most important things I want to share with you today is the concept of the polite trap. Law enforcement officers are trained in something called the interview style. They aren't going to come at you like you see in the movies, shouting and slamming doors. In fact, especially with seniors, they are often incredibly kind and deferential. They might call you sir or ma'am, ask about your health, or comment on a bumper sticker on your car. This is a psychological technique designed to build rapport. When someone is nice to us, our brains are hardwired to be nice back. We feel a social obligation to answer their questions. But you have to remember, an officer is working. Their work is to find inconsistencies. If they ask you, have you had a good day, and you say, yes, just coming back from a long lunch with friends, they have just established a timeline. If they later find out you left the restaurant at 1 de la tarde but it's now 3 de la tarde, they will ask where you were for those 2 hours. If you can't remember perfectly, which happens to the best of us, that gap becomes suspicious behavior under the 7-1 ruling. By simply not engaging in the polite trap, you keep that window of suspicion closed tightly. Let's talk about your home, because for most of us, our home is our sanctuary. It's the place where we feel most secure. But what happens if an officer knocks on your door without a warrant? This is where the 7-1 decision gets very granular. The court has suggested that if you open the door and begin talking, you may be inadvertently granting implied consent for the officer to observe bats behind you. Imagine you have a legal firearm for protection, or perhaps a collection of antique coins, or even just a messy living room. An officer's plain view doctrine allows them to use anything they see as a reason to investigate further.
This is why the protocol for seniors is different now. If the police knock, you don't have to open the door wide and invite them in for tea. You can speak through the door, or step outside and close the door behind you. It feels unneighborly, I know. It goes against everything we were taught about hospitality. But in 2026, your home is only a castle if you keep the drawbridge up. The 7-to-1 ruling essentially says that if you voluntarily engage, you are responsible for whatever evidence the officer gathers during that engagement. Now, let's address a fear I hear from a lot of you in the comments. Won't I look guilty if I don't talk? This is the biggest hurdle for pensioners. We care about our reputations. We don't want the neighbors seeing us being difficult with a patrolman. But here is the cold, hard truth of the American legal system. Looking guilty is not a crime, but providing evidence is a conviction. The 7-to-1 majority in the Supreme Court made it clear that the Fifth Amendment is there specifically for the innocent. It was designed to protect people who might get confused, people who might misspeak, or people who might be intimidated by authority. Justice Jackson, years ago, famously said that any lawyer worth their salt would tell a client to never speak to the police. If the highest legal minds in the country say that, why should we feel guilty for following their advice? You aren't looking guilty. You are looking protected. In fact, many officers secretly respect a citizen who knows their rights and remains calm. It makes their job clearer too. I also want to touch on the technical side of search and seizure in the digital age. For many seniors, your smartphone is your lifeline. It's how you see photos of the grandkids and keep track of your bank accounts. During a stop, an officer might ask, "Mind if I take a quick look at your phone to see your GPS?" In the moment, you might think, "Sure, I have nothing to hide." But after this recent 7-to-1 ruling, giving consent to search one thing often opens the door to searching everything. Your private emails, your financial apps, your personal messages, all of it becomes fair game once you hand over that device. The senior safety protocol is simple. Never consent to a search. Not of your car, not of your purse, and certainly not of your phone. You don't have to be aggressive about it. You can simply say, "I don't consent to searches." It's a powerful legal sentence that stops the process in its tracks. If they have a warrant, they will show it to you. If they don't, you have protected your privacy. Lastly, I want us to think about the legacy of protection we are leaving for our families. By practicing these rights, we are teaching our children and grandchildren how to handle themselves. If they see us being too helpful and getting caught in a legal snag, they will do the same. But if they see us standing tall, being polite but firm, and asserting our constitutional boundaries, we are giving them a survival kit for the modern world. This 7-to-1 decision isn't just a piece of paper in Washington, D.C. It's a boundary line around your life. It's a reminder that in the eyes of the law, you are an individual with unalienable rights. Don't trade those rights for the fleeting comfort of a friendly conversation. You've spent a lifetime building your life, your family, and your savings. Don't let a 30-minute interaction on a sidewalk put all of that at risk. Stay informed, stay silent when it counts, and stay empowered. We are in this together, and I will be here every week to make sure you have the latest updates on how to navigate this changing world with your head held high.